After the public school system denied his daughter admittance to a nearby elementary school, Kansas resident Oliver Brown had been forced to send her to another segregated school much further away from their home. Following this, Brown and several other local African American families gathered to file a class action lawsuit against the Topeka Board of Education in U.S. federal court, arguing that segregation laws violated their 14th Amendment rights. With assistance from the NAACP, this and other similar cases from South Carolina, Virginia, Delaware, and Washington, D.C. were combined into one and subsequently appealed before the Supreme Court. The laws involved in this case were the Equal Protection Clause of the 14th Amendment of the U.S. Constitution, which prohibits states from, quote, denying to any person within its jurisdiction the equal protection of the laws, unquote. Additionally, this case involved multiple state laws mandating racial segregation in public facilities, including public schools. Does the Equal Protection Clause of the 14th Amendment prohibit state-mandated segregation in public education solely based on race? In a unanimous decision, the court ultimately ruled that individual state laws mandating racial segregation in public schools inherently violated the Equal Protection Clause of the 14th Amendment. Chief Justice Earl Warren spoke for the majority, stating that so-called separate but equal public schools instilled a sense of inferiority which proved detrimental to African American students' quote, status in the community that may affect their hearts and minds in a way unlikely to ever be undone, unquote. The outcome of Brown v. Board of Education was undoubtedly a significant step forward in the fight for racial discrimination, one that paved the way for future legal challenges to come. While great strides have been made in the decades following the ruling, there is still much work to be done to address the various forms of racial discrimination that persist in our country today. Failing to enforce the principles of equal protection will result in perpetuating racial inequality, thus undermining the core values established in the Constitution. Therefore, I believe that it is imperative that we continue to ensure that every citizen is treated with dignity and fairness under the law. In 1958, Mildred Jeter, a mixed-race Black and Native American woman, had been married to Richard Loving, a white man in the District of Columbia. Upon return to their home state of Virginia the following year, they were arrested for violating the state's laws prohibiting interracial marriage. Following their trial, the Lovings' one-year jail sentence was suspended on the condition that they leave the state and not return after 25 years. In 1963, Mildred Loving sought assistance from U.S. Attorney General Robert F. Kennedy. After being referred to the American Civil Liberties Union, the Lovings filed a lawsuit against the Caroline County Court, arguing that the state laws violated their constitutional rights under the 14th Amendment. Following the loss of their trial, the Lovings then appealed their case to the Supreme Court. The laws involved in this case were the 14th Amendment of the U.S. Constitution, which states that, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, unquote. Additionally, this case involves Section 20-58 of the Virginia Code, which made it a felony for, quote, any white person and colored person to go out of the state for the purpose of being married and with the intention of returning, and be married out of it and afterwards return to and reside in it, cohabiting as man and wife, unquote. As well as Section 20-59, which similarly forbade, quote, any white person to intermarry with a colored person, unquote. Were Virginia's anti-miscegenation laws unconstitutional under the Equal Protection Clause of the 14th Amendment? In a unanimous decision, the court ultimately ruled that Virginia's laws banning interracial marriage were unconstitutional, and the Lovings marriage was legally protected under the 14th Amendment, thus invalidating laws from 16 other states which prohibited such actions. Chief Justice Earl Warren wrote for the majority, criticizing the state law's specifications on the prohibition of interracial marriage involving white residents, noting that, quote, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state, unquote. The victory of Loving v. Virginia had a significant impact on the civil rights movement in the United States, leading to greater acceptance and integration of interracial relationships and families. It also emphasized the importance of the Constitution's guarantee that everyone is treated equally under the law, regardless of race, ethnicity, or other characteristics. Even though great strides have been made in the decades following this ruling, racism and discrimination continue to be serious problems in our society today. Overall, I argue that this case serves as a reminder of why it is so important to remain vigilant in our fight against all forms of racial discrimination in the United States, in order to work towards building a more just and equitable society for all. In 1970, a Texas woman going by the pseudonym Jane Roe sought to have an abortion, but was denied due to a state law prohibiting abortions, with the exemption of certain emergency cases, such as to protect the life of the mother. Following this, Roe filed a lawsuit against Dallas County District Attorney Henry Wade, arguing that the state law violated her constitutional rights to privacy and autonomy. After the district court ruled in Roe's favor, the case was later brought before the Supreme Court for appeal. The laws involved in this case were the First Amendment of the U.S. Constitution, which states that, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The Fourth Amendment, which protects the, quote, right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, unquote. The Fifth Amendment, which prevents the federal government from depriving citizens of, quote, life, liberty, or property without due process of law. The Ninth Amendment, which states that, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, unquote. And the 14th Amendment, which states that, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, unquote. Finally, this case involves sections 1191 to 1194 of Article 1192 of the Texas Penal Code, which prosecuted anyone who were to, quote, designedly administer to a pregnant woman or knowingly procure to be administered with their consent any drug or medicine, or shall use towards her any violence or means whatever externally or internally applied, and thereby procure an abortion, unquote. Is it constitutional for state governments to restrict the right of an individual to abort a pregnancy? In a 7-2 decision, the court found that the Due Process Clause of the 14th Amendment protects an individual's privacy and autonomy, including the right to abortion. Justice Harry Blackmun wrote for the majority, noting that one's own personal beliefs concerning abortion, quote, ought not to conclude our judgment, unquote, therefore making any state laws preventing such procedures inherently unconstitutional and declaring the Texas law to be invalidated. Justice William Rehnquist partially dissented, criticizing the majority's interpretation of the 14th Amendment in regards to an individual's right to abortion, finding difficulty in identifying the, quote, extensive historical fact and a wealth of legal scholarship, unquote, in regards to the, quote, parts of it that invalidate the Texas statute in question, unquote. The Supreme Court's initial ruling on Roe v. Wade helped to affirm women's choices regarding privacy and autonomy as a fundamental right, including the choice to seek an abortion. However, the recent overturning of this decision threatens these rights, potentially forcing women to resort to unsafe, unethical, and illegal methods of pregnancy termination, which can lead to serious health complications and even death. Therefore, I argue that we must continue to fight for the protection of these rights in order to ensure that all women have free access to safe and legal reproductive health care.